So, welcome to the Contact webinar. We are not expecting a technical hitch, but please bear with us if we actually get one. So, those of you joining by PC, laptop, tablet, or anything else should be able to see this introduction slide now. When it comes to questions, there are so many attendees, we've decided that it isn't practical for verbal questions. So you will remain muted throughout. However, you can still ask questions, and you'll see on the slide there's a question mark at the bottom. That allows you to type your question into the text box, which gets sent to the webinar administrator, and then they're forwarded to us. And we'll select as many as we can at the end of the slide presentation, and probably condense a few as well. So, further relevant questions that we can't answer today, or they get very detailed, we're going to put some things up on the Contact website, along with a recording of this webinar, which will probably be ready next week. We hope that you will participate in the short questionnaire, which will launch at the end of the programme, because that always helps us with future online trainings. So, the subject today is the General Data Protection Regulations, and the webinar is for you to help you meet the data protection laws, the new ones, and prepare for them to come into effect on May the 25th. You have to hit the ground running on that day. That's not the date you start preparing, that's the day you have to be ready. So I'm Stephanie Linham. I'm the Senior Consultant for Advising Communities and the Senior Assessor for the Visible Quality Standard. With me is Kobe, who's their legal advisor. So I'll be doing the presentation and Kobe will be doing the questions at the end. So it's a long agenda today. So it's an introduction to the new legislation and the regulations that come into effect next year. We introduce terms like data controllers and data processors, which are quite important because they both have individual responsibilities and liabilities. There's going to be a whole new legal basis for processing information. Individuals get new rights and you have to meet those new rights. There's a difference between active consent as opposed to implied passive consent, which we will explain to you. You're going to need privacy policy and notices about the information you need to give to individuals about the information you hold and process. More on this later. Some key issues we think that you're going to hit as small organisations about the whole thing. And specifically, because of the nature of your organisation, how you have to process information about children and young people. Then I come up with the big stick, which is the impact and consequences of organisations if they breach the regulations, or not only that, don't have everything necessary in place and can prove it, and then some key steps for you to take. So, if you've all seen the Waitrose John Lewis ad, there's a monster under the bed. I think GDPR has become the monster under the bed. People are aware of it. They're a bit frightened of it. What we hope to do today is let's put on the lights. It's always less frightening if we put on the lights, and let's start looking at it. You are ahead of a lot of people because you are aware. Okay, so as I said, it comes into effect 25th of May next year, replaces the current legislation, so your old policies will be out of date. The whole point of it is designed to take into account modern technology. So much has happened. We all use social media, emails, and all the rest of it, and we've all heard about children and social media. And so it's the rights of individuals. Now, the actual definition of the data protection should still be with us despite Brexit. So we can't say it may go away. It is not going to go away. Now, there's a big but there. Today, we can give you an overview of the legislation and what's out there at the moment. But the regulations themselves are currently going through Parliament, so we don't have that to work on yet. The Information Commissioner's Office is responsible for actually keeping an eye on all of this, but they're still writing the detailed guidance. So we can't even offer you that. Thirdly, the legislation does apply to employees, both past and present, but the detail about how it will also comply with current employment legislation and workers' rights is unknown. Someone's going to have to work on that, so that's another watch this space. And the only way that things get proven is through court cases, because they set the precedents. Obviously, it's not in force yet. We've got no court cases, so we've got no precedents to work on either. So it's very much an overview today. So the key principles. So it applies to every organisation, and it doesn't matter how small you are or how big you are. It applies to everybody. A bit like employment law. Doesn't matter if you're one man and one employee or Google, the same laws apply. And it applies to services provided by organisations across the EU. The most important principle and the overriding principle is a bit like the Hippocratic Oath that doctors take, not to cause harm. So it does apply to data and information being held about employees, both current and past, volunteers, apprentices, job applicants, donors, members, but also service users and suppliers, which is quite a shock to some people that it brings in third parties. So this is all about respecting the fundamental rights that are laid out in the Charter of the European Union. That's respect for family life, for communications, protection of personal data, and right to effective remedies. I think those are the most important that I've picked out from there. Right, we're now going to talk about these new terms about the data controllers and data processors. So the data controller is basically the board or the management committee, whether they're incorporated or not, of any organisation. They're the strategic body, and it's those people that are ultimately liable and responsible. I've spoken to an awful lot of boards, and I'm trying to get it on their agenda, like health and safety should be on the agenda for board meetings. So should data protection be, because there are big fines and there are big responsibilities, many training issues. So it's getting up there at the forefront. So the data controller, the board, determines the purposes and means of the processing of personal data. They set the framework. So they have to ensure that data is collected, stored and processed in a way which complies with the regulations. Underneath the data controller, the strategic body, you're going to have individuals that are processing data, and they're called data processors. The data processors and the data controllers have to have a written agreement in place that they comply with the regulations, and how they put in place the technical and organizational measures, policies, procedures, technical measures, and all the staff training for board, volunteers, whoever actually processes data. I'm going to mention the data protection officer, and I'm quite confident it does not apply to you, but it is a term that you will be familiar with probably from your current data protection policy. So it's for large organisation whose core activity entails regular and systematic collection of personal data on a large scale. Those people have got to have a data protection officer. It's usually someone that they bring in because this person has to be qualified. It doesn't apply to the likes of you, I repeat. It does apply to the NHS, your local authority, Amazon and Google. The only reason that we're telling you about it is that you may hear the term and it's a different terminology to that you're currently operating under. And here we get down to the data processors, the people day to day who have the job of actually inputting and collecting data. So I repeat, there's got to be a written agreement between the data processors and the data controllers. The data processors have to comply with the regulations. They have to ensure they process and store data in accordance with the regulations. And there's a little bit of a nasty one here. A data processor can be personally penalised if they breach the regulations. That's given us a bit of a headache at this end because we're thinking it becomes very unattractive as a role and could cause a major barrier. So we've started thinking about how you risk manage that. Obviously, the first thing to do is adhere to the best practice. That should protect you if you're doing what you should do. But I do question whether it might be worth thinking about legal liability insurance. Some of you will have that for health and safety and employment, for HMRC audits. I would assume that there is going to be something out there that you can actually purchase that protects you. But no insurance will cover you for breach of regulations. Whatever you can do to protect your data processors and the organisation should be in the required written agreement and need some thought. So the legal basis for processing information, so lots of new information here. It becomes really important with GDPR because it directly affects the rights of individuals. We have to gather their consent and that gives them stronger rights. Now, again, I've got to say, I can tell you the principles. We've tried to think of some examples, but there is no detailed guidance yet. The legal basis is really important because as we go through this session today, you find that you have to actually say which of these legal bases you are using to collect data, and it should be in your data protection policy, and you have to let individuals know which of the legal bases you are using. So you need consent from any data subject and individual. So it's formal and appropriate consent, which we can go through on how you'll collect that. But it may be that you are at a training session, have quite a few people there, and they give verbal permission. The trouble is with that you still have to provide evidence. So even if you get verbal permission, you're going to have to start writing down who was there, when it was, the date, and that sort of thing. So in a lot of ways, it's much easier to get a formal written consent. Second basis, processing is necessary for the performance of a contract. Now, obviously, a contract is between two parties, and if you don't have the details of the parties, you can't draw up the contract. So you need to have some basic information. Thirdly, processing is necessary for compliance with legal obligations, and that might be a statutory duty to disclose information to the government, especially if you've got a contract with the government. Processing is necessary to protect the vital interests of a data subject or another person. The obvious one that we thought of would be safeguarding, which would be quite a major concern for you too. Processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. And that we were thinking scientific research, such as cancer research, where you actually need that data to prove or disprove a theory. And lastly, it's necessary for the purposes of legitimate interests pursued by the controller, unless those interests are overridden by the interest or freedom or rights of the actual individual, the data subject. So you need to choose one or two or whatever it is from that selection and actually include it in your privacy notice, which we'll explain later, and your new data protection policy. The rights for individuals and what this could mean for you. Now, bearing in mind our previous little chat, you'll start picking up here some of the issues that you're going to face. I have a right to be forgotten and ask you to delete my information. This is going to give us a bit of a problem with employees and volunteers, isn't it? So we think that there will be some mandatory information you can collect. We have no guidance at the moment, but common sense and practical purposes says there has to be. I have a right to ask you to change any information. I have a right to be informed as to why and what data you've stored about me and how long you're going to keep it for. I have a right to access any data you hold about me. And at the moment, you can make a small charge for that, but that looks unlikely under this legislation. I can restrict the processing of my data. I might not want you to include my gender or my age. So I can say, well, you can do it, but I don't want to disclose 2 or 3 things. I have the right to object or complain. I have the right not to be subjected to automated decision making. And this is where you automatically, as an organization, opt people in unless they actually specifically say no. And we'll go on to the consents in a minute. And data should be portable, so I can send it electronically, but only applies when it's personal data provided by me as an individual to the organization, and I've provided consent, and it's not automated. So again, if you think about it, this is going to give us some practical problems about employees and volunteers until we actually get the guidance. Very much watch this space. So I know I keep saying it, but legislation is yet to be tested and implemented. But here's what we know so far. You will need to have systems and processes in place to handle requests, all of those requests that I may make about deleting me, changing things. I want to see what you hold. And you've got 1 month under the regulations to comply with any request that I make. If you refuse to comply, and I can't think of a reason why you would, but if you did refuse to comply, I've got to tell the individual why I've refused. They can then complain to the Information Commissioner's Office and, worst case scenario, even take legal action. Consent for children and young people. So we're not sure what you do at the moment, but specifically going forward, you're going to need consent, either from the child or young person or from the parent. Now, who gives consent depends on the data protection bill which is going through, there is a suggestion that a child or young person over 13 years of age can actually provide consent. That's only a suggestion. It is not actually in the legislation or the guidelines yet, but it gives you an idea of what sort of age range they're talking about. I've mentioned before, you're going to need an updated and clear data protection policy stating what personal information is stored and what it will be used for. If you're collecting information online or on social media, you're going to need a disclaimer, but this can't just be tucked up and away in a corner and in gobbledygook. It's got to be somewhere obvious, easy to access, and in clear, plain language. And it states that all information is collected, stored, and used by the forum for example, research and evidence. But you also have to provide a link to your full data protection policy so that people can actually check it. You may already have, or you believe that you have, consent from existing users. I think it's a good time to actually look at that. Can you date the consent? Who gave you the consent? You know, are going to be things that you need to ask yourself, and it may be that you need to actually start the whole process again. So you need to ask consent for users of forums, attendees at events, before obtaining any of their information. And you've got to be able to document how you got that information and the evidence of consent. All consents need documenting and storing. Again, it's an obvious question, like, well, how long have we got to keep these for? We don't know at the moment, but that information will be coming out in the guidance from the ICO. I did mention at the beginning that it's also about third parties. So you may get data from other agencies, and therefore you're the data processor if they give you that information. You therefore need to have a two-way agreement between the third party and yourself, which sets out what both the parties do, where the data's come from, how it's used, how you'll store it, when you received it, who, if anyone, you're going to share it with, and all of that has got to be maintained on records of your processing activities. If you find the data is inaccurate, you've got to be able to talk to that third party to make sure that both of your databases are updated. So you need systems to show when and how people provided consent. You need a system in order to, if you get a request about my personal data, to be able to meet that one. And you must check the age of children as appropriate and get either consent from them, if that is allowed, or their parent, and gather and store all of those consents. So if you are questioned about it, you can say who, what, why, when, and where. Right, so this is talking, we've talked about consent throughout this session, so let's get down to the detail. So most of us will go online now, and especially if it's your bank or some agreement, up will pop a box that says, I accept, your terms and conditions. And this is, I've actually had to do something proactive to actually say I agree, as opposed to you saying, well, because you've donated to our organisation, we're automatically going to take it that you've consented to us using this information to email you. You cannot prove that way that the person read the statement and provided consent. So hence, you need something where you actively get them to give their consent. They must tick a box, and usually If you agree on a website, you can then go further into the process. If you tick I do not agree, then you can go no further. So this way you can pinpoint the date, how the person provided consent, and that makes it easier for you to comply with the regulations. Privacy notices, so we've mentioned those, so let's go into that in more detail now. So under the legislation, you are required to give people certain information. This includes you must provide your identity, who's asking, state how you intend to use that information, explain your lawful basis for processing the data, and that was that list where I said to you, you need to choose a legal basis, how long you're going to keep the data for, notify them of their right to request, change, delete all of their information, and their right to complain to the Information Commissioner's Office. And we've got the website up there, so worth keeping an eye on that one to see what guidance comes out from there. So if you currently have a privacy notice, you're going to have to update it to include that and be available for anyone whose information you will be storing. Again, the whole principle about this is clear language, concise, easy to understand, and easy to access. Key issues. Okay. We currently believe that controlling data storage and all the things I've been talking to you about is going to be difficult for smaller organizations. Again, some smaller organizations use third parties, so this is where you need the contract with people like do online payment processes or forums or cloud storage facilities, so that you have the same level of regulation compliance. You have to make sure that any third parties you're involved with are complying as well as you. So what do you need to do? Well, first off, it's the whole awareness for staff, your trustees, your volunteers, and that they're all trained to comply with the data protection policies, the new one that you're going to formulate. And we recognise this as a challenge, as you have so many challenges already for smaller organisations which rely on volunteers. You are required under the regulations to report any data breach to the Information Commissioner's Office within 72 hours. So you're going to have to think about how you get a process to actually advise your management committee that you have a problem. Now, some of you in your governing document will have the power to use electronic communication, and this might be where you can have a meeting where you don't have to get everyone together, and an email advice would be sufficient, but this depends what's in your governing document. So you've got 72 hours to tell your management committee and report to the ICO. Or if it's not a serious breach, being able to prove to the ICO why it has taken any longer. So larger organisations are going to have whole teams of people who are now overseeing data protection. But even in smaller organisations, we strongly recommend you have one person as a central contact point for problems, advice, notification to the management committee and the ICO. Someone needs to take responsibility. Now, the following slide you may think is a get out of jail free card. There is going to be a big but to it, though. So Article 30 contains an exemption. The organizations with fewer than 250 employees, so I can hear you getting excited, well, that means us, doesn't it? Are not required to maintain a record of processing activities. That's the name, contact details of the controller, reason for processing, description of the personal data, category being processed, how long the data will be kept before it's deleted, etc., etc. But this is where we get the but. Unless the processing of data is likely to result in a risk to the rights and freedoms of a data subject. But for you, we're suggesting processing is a regular activity and not occasional, in which case the get out of jail free card has just gone. So a company that processes data on a regular basis or processes these special categories, even if it's quite small, is not excluded under Article 30. Children and young people. So this is a reminder, but we think it's really important for you. So you need the consent of either the child, young person, or the parent, depending on the age. And that includes the use of any photographs. You're going to need systems to be able to verify the age of the child, young person. So if I say, well, I'm 13, I can give you, my own permission. How do you know that that's true? You need to get some evidence, some verification. So again, this is watch this space. We think it may be 13. We don't know that for certain. Oh, this is the nasty. This is the big stick coming out now. Right, so it's the ICO's job to monitor compliance. If a breach occurs, you have to let them know within 72 hours. If you report later than 72 hours, you've got to provide a reasoned justification, and we have currently no definition for that. If the breach is a high risk to the individual, the data controller, the strategic body, need to notify the individual subjects. And you'll all be aware of things in the paper about the NHS, let a load of data out available to lots of people. That would be a high risk. The ICO has the power to take action, and wait for it, to change the behavior of organizations. So it can be that you've had no actual breach of the data regulations, but for example, if you haven't got all the right policies and procedures in place, they may consider they need to change your behavior. And this is where the big stick can come out. There can be penalties imposed for organizations which cannot demonstrate that they are ready and have the policies and procedures in place. Financial penalties are pretty hard, so up to €20,000, or for bigger organizations, 4% of worldwide turnover, whichever is the highest. And that fine is made to the data controllers, the governing body. But additional fines of up to £500,000 for data controllers in order to change their behavior, on top of which data processors may also receive a financial penalty for breach. The ICO can also use criminal prosecution powers. Now, the good news is that the ICO have said that they have no intention of being draconian. They want to actually help people, but the powers are out there. Obviously not implemented yet, so we have yet to see how they will approach some of these issues. So, going back, a quick overview. What do we ask you to do? What do we think you should do? Training staff, volunteers, board, trustees, whoever is impacted this on how to process data, what to do with requests, and how to prevent breaches. Put in place appropriate data protection policies and procedures, which are signed off by the board management committee and applied throughout the whole organisation. So it's no good just having a policy in the corner. It has to be real, and everyone is applying the same process, whether it's a volunteer or a paid member of staff. You've got to have a person. I'm not suggesting that organisations of your size have a team, but you need one person whose role it is to oversee data protection and who is probably more informed than most about, does that fit, doesn't it fit, do I need to tell the board, what should we do about this? So somebody needs to actually take control and be a focus for this. You need to update your privacy policy. We've given you the details of what it needs to have in it. If you're doing surveys, website, and any other form of data gathering, now's the time to actually start thinking about a policy and putting one together. Update your website where you gather data to include all of that information that we've told you about consent, and letting people know why you are actually gathering the data, for what purposes. And introduce systems to verify the age of users where it's necessary, and to obtain consent from parents where necessary. And make sure that people are actively saying that they consent to their data being collected. It is not a default activity any longer. And look what you already have. Can you provide evidence of the user's consent? Can you identify where it came from and when? May well be that you don't, in which case we do recommend that you start collecting consents on a whole new basis. So advising communities are developing information advice and model policies for data protection and privacy. So keep an eye on our website. If you sign up to our free newsletter, we can easily keep you informed of progress, and we'll tell you in your email box, oh, go check this out so and so. We've finally got some more information. The ICO will also be publishing guidance and have a helpline for small businesses, and the number is there for you. We have been trying to ring it this week, and we're not sure whether it's manned yet, but we've not got a response. So it may be that until they publish their guidance, they won't actually really manage the helpline. So thank you from me, and I'm now going to pass you over to Kobe, who is going to look at your questions and give you some answers. Thank you.
From Carol. So if I start with the first one, she's asked, if people sign up as a member online via our website, there will be a dated entry. Does that constitute consent? It's difficult to say whether that is consent because it depends what you're asking when they sign up. So if they're just signing up to your website, that's not necessarily consenting to you to keep their information and to use their information. So you might need an extra step in there. So they join up via the website, but also consent to the use of their information and the storage of the information, everything that Stephanie's just talked about. Otherwise, I think that could potentially be an implied consent, but again, without knowing what the process is, it's a little bit difficult to comment. Carol also asks about members who've joined online over the past 5 years and whether they need to be contacted again. I guess that ties to the first part of the question. So if we don't think that they have actively consented to keeping their information, using their information, etc., then you might need to go back and have a look at what consent they've given and ask them again. As Stephanie said earlier in the webinar, it's good practice at the moment. So if you go back and have a look at all the people that you have got joined up over the last 5 years, see if you can identify if they have given consent and when they have, and go through the process. If you can't easily identify that information, then it would be best practice to ask them again. So I hope that helps. Carol's also asked if, or said it would be useful to have some suggested sentences to include on forums, membership forms. So we are working at the moment on a data policy and data notices. So those will come out via our newsletter. So if you sign up to the newsletter, you'll get the updates there. And another question from Carol about how long information needs to be retained. So at the moment, we don't know, is the short answer. And we're not given any guidance. So we're not told that you have to keep information for a certain amount of time. So the ICO has said that their guidance is going to come out at the end of the year. So we're pretty near to the end of the year. So we should think that it's coming out imminently. But it's a good idea to keep an update, keep an eye on their website for updates to see when this comes out. Got another question from Sue, who's asked, what is personal data? It's a good question. So personal data is anything from name, age, gender, bank accounts, street address, photographs, everything that's covered in some previous slides. It's anything that you can show a person's location, anything you can identify someone from. But the GDPR takes it a little bit further from the Data Protection Act, because it also now includes things that information gathered through cookies. So if you're looking at websites on your computer or your phone, it will pop up and ask if you consent. So that is another way of gathering information. So it covers anything and everything. Richard has also asked if verbal consent over the phone is an acceptable consent under the new regulations. So verbal consent is a form of consent, but the person who takes it over the phone would need to note down when it occurred, who gave the consent, a little bit of information about how it was gathered, and make sure that all of that information is stored. So you still need to, for example, if that person who's given you consent over the phone then phones back 2 weeks later and says, what information have you got about me? You'd need to be able to say, here's a file note. We know that you called on this date at this time and you spoke to such and such, and they have kept your data, you gave consent at that point. So you need to keep really thorough records of those kinds of interactions. So Jo Marie's asked a question about would an email to our database members explaining the changes to the Data Protection Act, also explaining what we do with information, and a survey for updating cover going back and checking with members if we have consent. So where did I understand your question, Jo Marie? So feel free to message in if I've got this wrong, but you seem to be asking about whether you could email out to everybody who has signed up already to explain the changes and to explain what you do with the information. So kind of a covering email. I think the only sort of, it would need to be personalized. It can't just be across the board, because each individual needs to be able to show that they've received it, that they've understood it, and that they have provided consent. So you wouldn't necessarily be able to just send out a large email just to say this is happening, this is what we're doing with your information. It does need to be done on a one-to-one basis, which I know is a little bit more tedious, but just got to make sure that you don't fall short of the regulations and their expectations, because don't forget that each individual has those 8 new rights and each of them can be applied, so you just need to make sure. So we've got another question from Joe, who's asked if we have any suggestions on how we can confirm date of birth of young people. whether you're going to need to ask for copies of passports or other official ID. It's a good question, Joe, and I think it depends how young people are engaging with you. So if you're not relying on the parents' consent, if it is a child who can consent, then if it's online, you're going to need to have a check. So somewhere in the questionnaire or whatever it is that they fill out to join as part of the online form, it would need to ask specifically for age. If you are, I mean, I suppose part of that is that we haven't got the definite guidance. So we don't know whether the expectation is for people to check IDs. But I suppose it would be quite similar to when a young person goes to buy cigarettes or alcohol and they have to check ID, and that has to be proved. So it may well be that level. Sorry, it's a bit of a roundabout answer to your question. I think we're all still learning as we go because we haven't seen how any of this comes into effect yet. Another good question from Wendy, actually, connected. If parental consent is given to use information about a child, when would we then have to go back and obtain consent from that child when they're older? Yeah, so it would depend on what the Data Protection Bill says is the minimum age, so what the age of consent is. So whatever that age is, then you would need to then ask the child directly. So you'd have parental consent up until whatever that age is, if it's 13 or 16 or 18, and then you would need to be asking the child direct. So you will need to have regular checks in place to make sure that you're complying with that. So Isabel has also asked what constitutes processing. Does simply storing emails for a mailing list constitute processing, or would you need to be using processes to select, for example, to mail certain age groups? There are exemptions in the processing if it's used for personal use. So if it's emails that are stored for personal emails, etc. But if you're talking about mailing lists, that is still an individual's information. So that's still an email address which can be used to identify an individual. So that would still constitute processing. So the storage of emails, the storage of the names that are connected to those emails, and any other information that you'd want. So, for example, if you were storing emails, which is divided by age groups, then you would be keeping the data that you'd be processing is the ages, the emails, the names, and that would still constitute processing. So you'd still have to go through keep records and go through the processes, which is definitely run through in the webinar. So I hope that's helpful. Don't know if we've scared you all, or if you've got more questions. Sue's asked, all our surveys are anonymous. Is this an issue? And again, I don't think that's necessarily an issue in itself. I think it just depends what you're doing with the survey responses. You'd have to stick with one of the legal basis for storing and using data. So if you're, for example, using surveys to gather information about health issues, then you would still need to comply, even if you're making the surveys anonymous. So you'd still need to be setting out at the start of the survey the reasons for the survey, what you plan to do with the information, and what the next steps are, who would see it, who would be shared with, etc. So you would still need to go through the same processes. And a comment from Isabel that it looks almost like we end up storing more personal data as a result of this and not less. And we would agree. Stephanie's nodding her head. It definitely, the regulations are bringing in more stringent requirements, which means to meet them, you have to keep more information than ever before. So we would agree with that. Question from Wendy about currently our members are the parents and carers, so it may be difficult to get older child's details to obtain consent, and when it may be required. I think the thing to go back to when you're dealing with parents and carers and children or young people is, who is it that the information is being stored about? So when the parents and carers are your members, is it about them and their experiences that you're storing the information? Is it because they are the contacts, or are you going into the children's information as well? So if if you are also trying to gather the information about the children, then you will need to follow the consent processes. And when they become older, if they're engaging with you directly and they can give consent themselves, you would need to obtain consent. So it really depends what you're doing with the information and data. Okay, so another question from Richard, who asks if consent needs to be constantly updated on an individual as more data gets supplied at later points in time. And that goes back to Stephanie's comments about which legal basis you're obtaining the information from. So, for example, if you have consent for an individual, or you have another legal basis for using their gender to be able to do reporting or whatever you're doing, then if you then take information that includes their address and their bank account details, you then have to ask for new consent, go through new processes, because you're then obtaining new data for new purposes. So you can't ask for consent as a blanket. We just want your information for whatever we decide to do. Undefined, it has to be defined. So if you do change the use of data, then unfortunately you have to start the process again. But if somebody has applied consent to specifically use that information, if you're still using it 5 years down the line, that's fine, as long as it's still in alignment with what they consented to in the first place. I've got lots of tricky questions today. Okay, it's quite complicated, the boundary between needing child consent or young person consent and parent and carer consent. As Carol said, that you're gathering information about children with specific names and ages, and only asking parents what the broad ages and needs are of their child or children. So the question being, do we need child consent? That's a really difficult question to answer. Yeah, so I think that depends on, so if you are gathering the information about the needs of a child, can you identify that child from that information that you are obtaining? If you can, then you need to consent. So the whole premise of the GDPR is that it's information that can identify an individual. That's the whole basis. So if you're not identifying children specifically, then the parent's consent probably suffice. But again, these are really small details that are really important for the work you're doing, but we're yet to really have that kind of level of guidance. So these are kind of our thoughts and our interpretations of how things look and what we've been told so far. But definitely, when the ICO brings their guidance out at the end of this year, which should be imminently if it doesn't get carried into the new year, this should hold a lot more information about these sorts of details to give us more of a clear steer. And we're not yet sure of what the age of the children or young person is yet, because we're still waiting for the data protection bill to come in and define that. So I think that kind of comes to Sue's question about, are we talking about secondary or primary school children? And that is a little bit undefined at the moment. Young person is very broad category. But we should know, we haven't been told when the data protection bill will become an act. Usually it will take quite a few months for it to come into effect. So we're still watching this space. Okay, Wendy's asked a further question on the point about parents and carers and young people. I think probably what would be best is if we go away and really think about that one a bit more detail rather than we try to answer it, because it is quite difficult to give that kind of. Isabel's asked about pay details that you save in your bank account, for example, when expenses are paid online. That is personal data that would be covered by the GDPR. So you would need to have their consent to store their details and their bank account details and that information, because that is able to be tracked back to the individual. Great. Well, thank you very much, everybody, for joining us.
And thank you from me, and thank you to Kobe. That was absolutely brilliant. Thank you. Unfortunately, we don't have the guidance yet. So some things we can interpret, some things we say, well, actually, we're quite clear. But, you know, it's a learning phase for us all. Can I remind you, so it's thank you from us, and there's going to be a short questionnaire launching in just a second. It would really help us if you would spend a few minutes on completing that. So thank you once again. Thank you to Kobe. And please look out for our website, sign up to our newsletter, keep an eye on the Information Commissioner's Office website. Lots will be coming out, and it's just finding a way that we can actually prod you in the arm and say, this has happened now. So it's just for you to be a little bit active. It's going to get clearer, we promise you. And thank you and good luck. Goodbye.